sitting in front of us. But instead, they did whatever they did, whether it was divine intervention or what have you. They lacked subject matter jurisdiction. The real petition lacked any factual basis establishing that either Monica or the children resided in Florida at the time of the filing, or that they had minimal context necessary to invoke Florida's jurisdiction. I believe at the time she lived in North Carolina. And so what would have been proper, and for anybody who has the situation, I'll say it now, not that I'm giving away any freaking secrets, you know, it's not like this is, what's that thing, National Treasure with Nicolas Cage and no shit. If the original state of North Carolina had served Chagret Doss, what would have happened is they would have been able to forward the case. Then they could have sent it to Florida after they established an order. North Carolina never served me. Never did anything to establish that. Florida just did it, which is just kind of crazy because they're attorneys. They should know better. Just like they should have known better that once you actually saw me in front of you, I can't waive subject matter jurisdiction. I could have waived personal jurisdiction. So had she been in Florida and a whole lot of other things happened, I possibly could have waived it, with the exception of the fact that you didn't serve me in 120 days. And the rule required that you do these things. And by the way, I'm going to show y'all something that's going to help everybody out when we go to our Westlaw edition of this. A court can disregard certain things they have discretion in. They don't have discretion to disregard law and rules. They have no discretion. That's not an abuse of discretion. I'm going to show you that so you don't think Greg is making it up. I'm not that creative. That's called an error of law. And if it were me, because I'm not going to give anybody any legal advice, if it were me, I would be searching more for errors of law than worrying about whether the court abused its discretion. Because if it were an error of law, it would probably require reversal. Anybody got any questions? You can hit the action button, I think, and it'll pop up and you can show your hand or whatever. Look for the errors in law. A lot of the other stuff won't even matter. So, again, improper amendments, remember that they violated the rule. You can't amend the complaint without, you can get one amendment without leave of court, and that's within the first X number of days. And if the other party doesn't respond, you can amend it without leave of court. After that, you have to get permission from the court, at least in Florida, to amend your petition. They didn't do it. You can certain things you can get around, can't get around the rule. And she administratively closed, no problem. Improper enforcement. So I just put it out here in this and stated here you go, people. Laid out my issues, showed them the rules, applied the rules to the issue, and then concluded as to why I'm entitled to relief. See, this is what I asked for. And then I incorporated a declaration, a non-notarized affidavit, and then I I sent the judge my proposed order. And this is all she has to do is say, okay, this is what I'm looking at. In fact, there's no original petition in the court record, which is kind of weird too. Failure to service. All I need her is to declare these things which are actually evident on the record.